A major shift just took place in America's gun laws. For years, getting a concealed carry permit meant dealing with endless paperwork, vague approval standards, and officials who seemed more interested in blocking applications than following the Constitution. That era is now finished. The Supreme Court just issued a massive 6-3 decision that goes far beyond striking down one particular law. This ruling tears apart the entire framework states have used to restrict your ability to carry a firearm. This wasn't a minor adjustment or a small change. This represents a complete overhaul of the system. Courtrooms across the country are already feeling the impact. State laws are crumbling, and politicians who oppose gun rights are scrambling to respond. If you want to understand exactly what happened and how it directly impacts your life, you're in the right spot. This is Rights and Reloads, where we cut through the noise and give you straight facts about the legal fights that determine your freedoms. Make sure to like this video and subscribe so you stay informed. Today, we're breaking down what this 6-3 decision actually says, why it carries more weight than most people realize, how different states are responding or pushing back, and what all of this means for you as a responsible gun owner. Let's jump right in. The Supreme Court delivered this decision with serious force. 6 justices voted in favor, 3 voted against. But the real significance isn't just in those numbers. It's in what the court is telling everyone. A 6-3 vote shows a solid constitutional majority, not some close call that could easily flip. This sends a clear signal to lower courts across America that they need to take the Constitution seriously and stop playing games. It also puts states with strict gun laws on immediate alert that their regulations will face serious legal challenges. The case involved a state permit system that basically made citizens ask for permission before they could carry a handgun outside their homes. The Supreme Court shut that down completely. They ruled that your right to bear arms doesn't stop when you walk out your front door. It doesn't depend on whether some local official approves of you personally. And it absolutely doesn't require you to prove some special reason or wait through unnecessary delays. This decision fundamentally changes how things work. If the Second Amendment protects something, you don't need anyone's permission to exercise that right. That's the bottom line. To really grasp why this matters so much, we need to look back about 100 years. These permit laws didn't originally start as genuine public safety measures. They began as tools to control and discriminate against certain groups. Right after the Civil War ended, Southern states created black codes designed specifically to prevent freed slaves from owning guns. Then in 1911, New York passed something called the Sullivan Act, which required permits to carry firearms. The real purpose wasn't public safety. It was aimed at disarming immigrants and working-class people. Throughout the entire 1900s, cities and states in various regions copied this playbook. They created high fees, unclear approval standards, and rules that were nearly impossible to satisfy. Courts largely refused to step in, treating the Second Amendment like it mattered less than other constitutional rights. By the early 2000s, America was split between 2 types of states. May-issue states gave officials the power to deny permits for almost any reason or no reason at all. Shall-issue states were somewhat better, but still loaded with delays, costs, and complicated requirements. This 6-3 ruling challenges that entire history and system. The fundamental point is that constitutional rights aren't prizes you earn or rewards you receive. They're guarantees you already possess. This ruling didn't appear out of nowhere. It builds directly on a major case called Bruen from 2022. In Bruen, the Supreme Court told judges to stop using balancing tests where they weigh public safety concerns against constitutional rights. Instead, if a gun law doesn't have roots in historical text and tradition, it's unconstitutional. Period. Bruen changed everything by making it clear that courts can't simply declare that a law seems reasonable or makes them feel safer. States can't hide behind vague phrases like public safety anymore. Judges now have to ask a specific question. Would this type of law have been acceptable in 1791 when the Bill of Rights was adopted, or in 1868 when the 14th Amendment was ratified? This 6-3 decision is basically Bruen with even more teeth. It takes that historical test and applies it with full strength to permit systems and potentially to weapons bans, waiting periods, and other restrictions too. The message to judges is crystal clear. Stop making up new rules based on current political pressures. Start honoring what the Constitution actually says and has always meant. Within hours of this decision coming down, states across the country went into emergency mode. Some rushed to rewrite their laws to try to comply. Others refused to back down and started preparing for legal battles. The reactions came fast and furious. California attempted to revise its carry law, but then expanded the list of sensitive places where carrying is banned to cover huge portions of entire cities. New York passed something called the Concealed Carry Improvement Act, which many people argue actually made the situation worse instead of better. New Jersey doubled down by keeping strict limits in place and even adding requirements that gun owners must carry liability insurance. Meanwhile, Texas, Florida, and Georgia moved in the opposite direction, embracing constitutional carry laws and pointing to this Supreme Court ruling as justification for their approach. At the same time, gun rights organizations like GOA, FPC, and SAF started filing lawsuits in every federal circuit, using this ruling as powerful new ammunition against old restrictions. The result has been a legal earthquake, and the aftershocks are still rolling through the system. If you thought states with strict gun control would just accept defeat and move on, you'd be completely wrong. They're fighting hard to maintain control, but their strategies are starting to fall apart under scrutiny. Here's what they're trying. They're expanding sensitive places to ridiculous levels, claiming that guns should be banned in airports, parks, churches, parking lots, and almost everywhere else. They're requiring liability insurance before you can legally carry, which creates a financial barrier. They're imposing excessive training requirements, charging high fees, and creating mountains of paperwork to wade through. They're passing emergency laws designed to slow down new permit applications or delay court rulings. But here's their big problem. None of these tactics have any basis in American history. There were no sensitive zones covering entire neighborhoods in colonial times. The Founding Fathers didn't need to buy insurance policies before exercising their right to bear arms. They didn't have to get approval from British officials or fill out forms proving they deserved their rights. That's exactly why these new state laws are already being challenged and defeated in court. This time around, judges can't rely on the old excuses they used before to uphold restrictions. The message from the Supreme Court is simple and direct. You cannot ban a constitutional right just because it makes you uncomfortable or worried. This Supreme Court ruling did far more than eliminate one specific law. It completely redefined how every Second Amendment case must be evaluated going forward. The court established a clear test that cuts through political arguments, emotional appeals, and manipulation tactics. Here's exactly how the new framework operates. First, text matters. The plain language of the Second Amendment is the starting point, and it means what it says. Second, history is crucial. Judges must examine laws and practices from 1791 or 1868, not modern anxieties or current politics. Third, tradition counts. If there's no historical equivalent to a modern restriction, that modern law cannot be upheld. Fourth, no more balancing. Public safety arguments don't automatically trump your constitutional rights anymore. Fifth, precedent gets reset. Courts across America must follow this method now, with no shortcuts or creative workarounds allowed. This new standard wipes away decades of judges making decisions based on their personal views or political preferences. It reminds every judge that their job is protecting constitutional rights, not inventing exceptions based on contemporary concerns. For gun owners, this means that dozens of outdated and questionable laws are now on shaky ground and likely won't survive much longer. The Constitution isn't something that gets reinterpreted to fit modern politics. It's being restored to its original meaning and strength. Major Supreme Court decisions can seem abstract and distant until they actually affect your everyday life. This 6-3 decision isn't just about lawyers arguing in courtrooms. It's about your carry permit, your ability to travel, and your peace of mind when you're legally armed. Here's what changes right away. Good cause requirements and may issue systems are collapsing rapidly across the country. When it comes to traveling, more states may soon be forced to recognize permits from other states. During traffic stops, legally carrying a firearm is now presumed lawful activity, not something suspicious that gives police reason to treat you like a criminal. Even shall-issue states might evolve further into full constitutional carry systems where no permit is needed at all. For self-defense situations, you now have real confidence knowing the law is genuinely on your side instead of creating legal traps. This ruling returns power to ordinary people. Millions of Americans who previously worried about legal consequences for simply exercising their rights now stand on solid constitutional ground. You're no longer filling out applications and begging for permission to exercise a right. You're freely and lawfully exercising it because it belongs to you. The message couldn't be clearer. The right to bear arms is not up for negotiation or debate anymore. No decision this powerful comes without serious backlash. This one has triggered political chaos in Washington, in state capitals, and across media networks from coast to coast. Here's what's been happening since the decision came down. Senators like Schumer, Murphy, and Feinstein are proposing new federal restrictions to try to work around the ruling. Blue states are attempting to redefine carry zones, making almost every public place off limits. Insurance mandates and special taxes on gun owners are being suggested as potential workarounds. Red states are pushing forward with new constitutional carry laws and using this court ruling to justify their approach. The 2026 midterm elections are already shaping up to be a major battleground over this decision and gun rights generally. This has moved beyond just legal questions. It's now about ideology, elections, and political control. That means the fight is nowhere close to being finished. Gun owners have the law and the Constitution firmly on their side now, but they'll need to defend that victory in the political arena too. When freedom wins a major round, the opposition doesn't just give up and go home. They regroup, reorganize, and look for new angles of attack. This ruling focused specifically on carry permits, but its effects are just starting to ripple outward. Every major gun control law in America is now vulnerable to legal challenge, and lawsuits are being filed at a rapid pace. Here's what's already being attacked in court. Assault weapons bans are already being struck down in multiple federal circuits. Magazine capacity restrictions are being challenged and defeated using arguments based on Bruin. Waiting periods are being questioned because there's no historical precedent for them. Sensitive place laws where cities try to ban carrying almost everywhere are losing in court. Training mandates and excessive fees are now being challenged as unconstitutional burdens on a fundamental right. This decision didn't end the legal battle over gun rights. Instead, it opened a floodgate of new challenges. Gun owners and their legal advocates are finally playing offense instead of constantly defending against new restrictions. This Supreme Court ruling is the battering ram that's breaking down every unconstitutional barrier that's been built up over decades. Every generation faces a moment when the true meaning of the Constitution gets tested in a serious way. For the Second Amendment and gun rights, this 6-3 ruling might be that defining moment. Here's why this decision matters so much historically. It doesn't try to balance your rights against other concerns. It restores them to their full strength. It declares that gun rights are equal to freedom of speech, freedom of religion, voting rights, and every other constitutional protection. It challenges an entire century of laws that were built on fear and political agendas instead of freedom and constitutional principles. It sends an unmistakable message to every judge in America to start defending liberty again instead of finding creative ways to restrict it. It reminds politicians at every level that the Constitution isn't a suggestion or a guideline. It's the supreme law of the land, and it's binding on everyone. This isn't just a victory for people who own guns. It's a win for everyone who believes that constitutional rights don't require permission slips from the government. It represents a return to first principles and to the vision that the founders had for America. And this is only the beginning of what's coming next. So here's where things stand right now. The Supreme Court just completely reset the rules for gun ownership in America. States are panicking, resisting, or scrambling to rewrite their laws. And gun owners like you are finally standing on solid constitutional ground that won't shift beneath your feet. But this isn't the end of the story or the final chapter. It's just the first major battle in what will be a much longer war. Even though the court has made the law crystal clear, politicians are already plotting their next moves and looking for workarounds. That's exactly why you need to stay sharp, stay informed, and stay actively involved in the fight. This is Rights and Reloads, where we don't give you politics or spin. We give you the raw truth about the legal battles that are shaping your future and your freedoms. Make sure to like this video, subscribe to the channel, and turn on notifications so you don't miss a single update as this situation continues to develop. Share this with fellow gun owners who deserve to know the truth about what's happening. The more people we educate and inform, the harder it becomes for anyone, whether in Congress or a governor's office, to steal your rights while operating in the dark. Stay free, stay armed, and stay ahead of what's coming next.